What does Title IX require of schools to ensure equal athletic opportunities for the sexes? When do schools need to recognize student demand and create new athletic opportunities for female athletes? Jamie, you've got some Canadian roots. Have we finally found a sports case for you?
You know, I think it's a common myth that all Canadians play hockey. At least one of them does not, and that's me. Nor do I curl. I do not play curling. That is another Canadian sport there.
Though the U.S. men's did win the gold medal in curling not too long ago. So if I remember correctly, that was a pretty huge upset.
Yeah, I think I remember that too. I remember that too.
Yeah, we got really into curling in college because of the Olympics.
I am not ashamed to admit that I can watch a little bit of curling every now and then. If it's on TV, I'm not going to, stop what I'm doing and watch it.
Oh, it's edge of the seat stuff. It's such a fast-moving sport. Unlike hockey, which actually is.
Hockey. Now, hockey is I can watch hockey.
See, maybe we did find a case for you. Yeah. We just talk about sports a lot for some reason, and we never seem to find one that resonates with both of us.
That's right. Okay. Well, so obviously you've probably gathered that we're going to talk a little bit about hockey today. So we're going to take the ice with another athletics case, everybody. This time we're skating our way through a Title IX claim. Involving some female athletes who were denied the opportunity to play hockey through their school-sanctioned club sports program. We're going to dive into some of the intricacies of Title IX in the 2022 case of Brooks versus State College Area School District. We felt like we really had to do this case. We couldn't not do it because, as Wayne Gretzky once said, and the court in this particular case,
that's right,
you miss 100% of the shots you don't take. So we're doing this.
Yeah, let's take our shot.
Okay.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Jamie, you have our bell ringer for today?
I do, yes. This article I came across the other day, News 9 out of Oklahoma.
Uh-oh, the new Florida.
Yeah. Well, this was an interesting one. So, we've talked about the state superintendent there in Oklahoma who said everybody has to teach the Bible,
right? The Bible mandate.
Yeah.
Or the Bible memo. It wasn't even a mandate.
Right. It was a memo. And I think we talked about how there were a lot of superintendents or districts that were just kind of like saying, no thanks. This isn't in the state regulations, and we have the ability to kind of establish our own curriculum, and thank you for your input, but we'll decide what we're teaching. Yeah, so Oklahoma and Oklahoma's state school superintendent has been in the news quite a bit, and so this article is about something else that he did.
And I'm guessing it's not, I learned my lesson from the last one.
Oh, no. This is a doubling down.
Okay.
So apparently, so the state superintendent of education there in Oklahoma, his name is Ryan Walters. And apparently around the middle of November, he emailed every Oklahoma superintendent saying that he's going to require all Oklahoma schools to play this 90-second video to all enrolled children and send it to their parents.
Whoa.
And
so first, before we even get into the video itself, right? He sent all the superintendents an order essentially to show everybody, all their constituents this video. Like, where does he have the authority to do that? Right? Because if I get that email as a superintendent, I'm just like, cool, thanks, delete.
Yeah. And what's a little confusing here is that the superintendent's office might have recalled that email. I think there was one district in this article that indicated that the email had been recalled.
Interesting. Okay, so this is something that happened, which may or may not still be
happening.
An ask.
Yeah.
Okay.
Yeah. I don't know for sure. But the reason why we're mentioning it is because its contents are kind of interesting. And I think its contents have some legal implications. Which is why we're talking about them on the show.
I appreciate you using the word interesting, because that's the word I use too when something is really, really complicated and very value laden. Interesting is just a good catch-all for that sort of thing.
Well, that's the word that I'm using while we're recording. Before we started recording this, the words had fewer letters, four to be exact. So in this video, Walters explains why he created, within the State Department of Education, why he created a Department of Religious Liberty and Patriotism. We have absolutely no idea what that department is going to be responsible for, who's going to be in it, if it's actually going to happen or not. I don't know.
Okay, but we have the name.
Yes.
Which is the Department of Religious Liberty and Freedom.
Yes, which is potentially problematic from a legal standpoint in and of itself.
Yeah, for at least two reasons. But like, I feel like I just woke up in 1984. Like, that is so...
And your name is Orwell? Yeah.
Right, yeah, right? Like, okay. So it's the Department of Religious Liberty and Patriotism.
Yeah.
Okay.
Should I play the audio of the video?
Yeah, let's hear some of it.
We are excited to announce a new office here in the Oklahoma State Department of Education. That will be the Office of Religious Liberty and Patriotism. For too long in this country, we've seen the radical left attack individuals' religious liberty in our schools. We will not tolerate that in Oklahoma. Your religious liberties will be protected. We've also seen patriotism mocked and a hatred for this country pushed by woke teachers' unions. We will not tolerate that in any school in Oklahoma. We want our students to be patriotic. We want our students to love this country. And we want all students' religious liberty to be protected. I will now say a prayer. And to be clear, students, you don't have to join. But if you so wish, I'm going to go ahead and pray. Dear God, thank you for all the blessings you've given our country. I pray for our leaders to make the right decisions. I pray in particular for President Donald Trump and his team as they continue to bring about change to the country. I pray for our parents, teachers, and kids that they get the best education possible and live high-quality lives. I also pray that we continue to teach love of country to our young people and that our students understand what makes America great and that they continue to love this country. Amen.
Okay. So,
yeah.
This is just a bell ringer, so we can't necessarily spend all day on this one.
Right, which I think we probably could.
We could.
Yeah.
I think we could. Listen, there's a few things in there I could get on board with. We want kids to live high quality lives.
Yeah, the best education possible, right? Like
100%. But there were some other things in there that, listen,
right.
All I will say is we all have our beliefs and our values and our sort of political views and things like that. And again, this is just a bell ringer. We could get into a lot of this, but like just sticking to the legal aspects of what's going on here.
Yeah, there's a number of concerns.
Is a little concerning. Yeah.
The Establishment Clause concern, like first and foremost, right? Like the Supreme Court, the United States Supreme Court has said, like, we can't have school-sponsored prayer at graduation ceremonies. We can't have even like student prayer that is like school endorsed, essentially, at football games, right? Like,
yeah. And they've also said that you can't, as representatives of the state, right, as state actors, you can't even get up in front of a bunch of students and say, now we're going to take some time to pray.
Right. You can do moments of silence.
Yeah.
Yeah.
Like,
right.
Because there's a coercive aspect there.
Absolutely.
There's the state
right.
Speech. And and all of that stuff. So even him saying, I'm going to pray, I welcome you to do it with me. You don't have to, whatever.
Right. That is coercive.
That's coercive. And that has been problematic according to the courts in the past.
Though there's been a recent line of Supreme Court cases that have allowed for religious invocations before public meetings. So there is a line, and they rely on history and tradition for that. So maybe that, but this isn't an invocation for a public meeting, right? This is a message that State Superintendent of Education wants schools to send out, right? So it doesn't really fit into that bucket either. And the thing, I guess the bigger, zooming out a little bit, there's kind of there's the Establishment Clause concern, but the kind of the flip side of that coin is the free exercise concerns, or the freedom of conscience that students have. And that's kind of why coercion is so important and such a big concern here, is because we don't want to basically compel or coerce people to believe in certain ways as the state. That's not the state's job.
Right.
And this freedom of consciousness thing, in the 1943 West Virginia v. Barnett case, that was the flag salute
patriotism case, right?
Right. Yeah. And the Supreme Court struck down a law
that required people to
salute the flag and to say the flag salute, right?
Yep.
And so they said, and I don't have the exact quote memorized, but and I'm going to paraphrase it here. They said, if there's any fixed point in our constitutional constellation, it's that no official, high or petty, can prescribe what shall be orthodox in politics, religion, or other issues of ideas or value.
Well, I think you did a very good job there of recalling something that you don't have in front of you.
I stumbled at the end a little bit, but the gist of it is we don't want the state to be forcing by act or belief, what we want to believe about these different ideological issues. Right. And so this idea that we need to teach patriotism is by itself problematic. And I'm not poo-pooing patriotism, right?
No. That's not what this is about. Right.
Right.
It's about what the law has said
about these issues, right?
Yeah, exactly.
I've called it the anti-indoctrination principle, right? Schools need to create the opportunities for people to form their own beliefs and values and opinions. And so we can't really put our finger on the scale to twist those in whatever ideological way our current leaders might want.
Right.
That's why I call this department Orwellian, right? Because it seems to be putting its whole hand on the scale.
It's a big hand, man. It's a big hand. Well, we know that at least shortly after this video came out, the state attorney general's office, and remember, we've talked about the state attorney general before, Gentner Drummond. I don't know. Gentner. Anyway, he's Republican, but shortly after this video came out, the AG's office said basically, I found the quote. It said, not only is this edict unenforceable, it is contrary to parents' rights, local control, and individual free exercise rights. Unquote. That's what the AG's office said. And we also heard from a number of superintendents in Oklahoma basically saying, we're not going to play this video. This is clearly he's overstepped his bounds. I think one school official said that they didn't believe that he has the statutory authority to require the district to share that content. So we will not be showing the video in classrooms or sending it to parents. So it's just another really interesting, these political tensions are really, really interesting, how they're being manifest in schools and in school systems and in states. Anyway, okay, let's talk a little bit about Title IX, hockey.
No pun?
No,
you're just going to skate on by the opportunity for a pun?
Yeah. Are you giving me a penalty? A penalty? Okay. All right. Let's start this thing. Jeez. All right. Now we have one listener left. Okay. So this case is all about a group of middle school girls who wanted to play ice hockey. Simple, right?
Yeah.
You want to play ice hockey? Play ice hockey.
Let them play.
Yeah. Well, not very simple. Okay. So we've got upset parents. We've got an inflexible school district. We've got a parent-run booster club that seems pretty bent on not compromising here. And caught in the middle of all this stuff, there's a handful of young girls who just want to play hockey.
Okay.
All right? So that's how we're setting up the stage here.
That sounds like a good drama.
Yeah, that's why we're covering it here. So this is all taking place in State College, Pennsylvania, which, as many of you probably know, that is a lovely little college town in Pennsylvania that is home to Penn State University.
Yeah.
Okay, the State Area College School District, it has ice hockey teams that are sanctioned district club sports teams that compete in the Laurel Mountain Hockey League. To be a district club and compete, the ice hockey teams are required to be chartered by a sponsoring school and to have an academic advisor employed by the school district. Also involved in all of this is the District Ice Hockey Club, which is a parent-run booster club organized to help facilitate the district's ice hockey clubs at the various levels. Okay, probably like arranging rinks and maybe coaches and equipment.
Yeah.
And because the school, most likely the school district does not have the facilities and the whatever. So there's this partnership here.
Okay. So basically you've got these club teams that have to be sponsored by a district, but it seems like they're kind of facilitated by this organization, the District Ice Hockey Club.
Yes.
Okay.
Yes. Okay, so it's important to note here, though, that the Ice Hockey Club does not have the ability to enter a team into the hockey league without school sponsorship. Okay, so the Ice Hockey Club can't just sort of act unilaterally and create new teams.
Okay.
Okay.
But does that mean that the school could act unilaterally? Like, if all you need is a school-sponsored club to compete in this league, it seems like then that means that the school could create its own club.
I am not sure. I don't know
if
I read in there that those restrictions.
What the dynamic is.
I'm not 100% sure.
Yeah. But at the very least, in order to compete in this league, you have to have a school sponsorship.
Correct.
But we've got this other entity involved
Right.
about like organizing and managing the teams. And we don't know exactly what that looks like.
Right. Okay. So according to the student's complaint, from 2004 to 2016, 12 years, the district had 1 or 2 middle school ice hockey teams based on interest.
Okay.
Okay.
That second team is going to become really important, I think.
As we will talk about in a second, because in 2022, everything changed.
Okay.
So up until 2020,
that's the year this case came out. I wonder what happened.
Look at that. Up until 2022, there had been a private girls ice hockey team that was run by a local ice rink, so completely unaffiliated with the district or this hockey club. Okay. It was just one of the local ice rinks, had a private girls ice hockey team, but in 2022, the rink discontinued that team.
Okay.
Okay. So what happened was the girls who had been on that team, they reached out to the ice hockey club to let them know that they were going to be trying out for the school teams now. And there was probably going to need to be a second club to accommodate the increased interest that was generated after this rink stopped their program.
Right. Yeah. So they're not going to play on the private team anymore. So now they're going to come and play for the school's team.
Yes. Now, in April 2022, we have the middle school ice hockey tryouts. 34 students attended the first set of tryouts, including at least 4 girls.
Decent tryout.
Yeah. Later that month, there was a second round of tryouts. We're not exactly sure of the total number of students that showed up there, but at that point, there were only 3 girls that were participating in the second round. Then at the end of April, the final roster for the single middle school team was posted. Remember, from 2004 to 2016, there was either 1 or 2 teams based on interest.
Yeah. And now we've got 1 team.
So now we've got 1 team that had 19 players, and they were all male. None of those 3 girls that ended up at the second round of tryouts made it onto the team.
Oh, no. Okay. So we had at least 34 students try out. 19
initially.
made it.
19.
Yeah, so we've got 15 who didn't make it, and all the ones who didn't make it.
But we're not 100% sure how many folks we lost from the first tryout and the second tryout.
Yeah.
Okay, we know we lost 1 girl. So
19 also seems, that's a pretty big team, isn't it?
I am at risk of losing my Canadian citizenship right now if you keep asking me these hard questions.
I've been to one hockey game in my life. So
I've been to
this is the sport I know the least about that we've covered.
So we've got these 19 players on this final single team. Okay. None.
Which didn't
girls.
include any of the girls. Yeah.
Right. So the girls' parents are a little upset. They ask the school to create a second team. All right.
Okay.
That seems relatively in line with what history has had. You know, there's
Right.
interest. So why not create a second team?
Yeah. You could do 2 teams. I mean, it sounds like you cut almost half the people who tried out potentially. Again, we don't know the exact numbers, but it seems like you could distribute the interests pretty easily there.
I would think so. But the school decides not to do that. Interestingly, the school gave a number of reasons for not creating a second team. And here are those reasons. These are fun. The first reason is they didn't have enough available rink time for a second team.
Okay. So logistically, like
Resources. Yeah. A lack of resources. They weren't sure if it was the school or the ice hockey club that actually made the decision about whether to create a second team. So now we're starting to see maybe some finger pointing going on.
Or some breakdown in, at the very least, communication, right?
Yes. And collaboration.
Yeah, because the league that they compete in requires school sponsorship.
Right.
But
the school is saying...
The school seems to be saying, like, we can't tell them to create a second team.
Right.
Okay. Interesting.
They also explained that there were safety concerns about having more than 19 players on the ice at a time. I don't know they must be talking about practices because I don't know any hockey games that have 19 players on the rink at the same time.
Right. Well, yeah, that's probably what it is. Like practice time, because if they don't have available rink, then like I guess the implication is that they will practice at the same time. And if they're doing that, you're just going to have these teams like running into each other, I guess.
No, that was one of the reasons they gave. But importantly, though, the district also did not dispute that having a second team would have any adverse financial impact on the school. So they did say, we're not making this decision for cost reasons, for financial reasons.
So they're basically going like logistics and then also this ambiguous authority on who has the power to approve a second team.
Correct. So, so there's a bunch of back and forth that happens between the parents and the district and the hockey club and whatever. And then on May 17th, 2022, the girls and their parents gave notice to the district and the ice hockey club that they had enough interested players to start a second team. So now it's not necessarily a question of having more than 19 players on the ice at a time because we could potentially have 2 teams. So it's not about adding players to the first team. It's about adding a second team.
And they've got enough interest, it sounds like, to do it.
They've got enough interest, yeah. So they also let them know that they had coaches and they already secured designated separate ice time that wouldn't impact the other middle school team. So basically they're coming back and they're saying, every reason that you gave school for not doing this, we've got a solution for that.
We solved it, yeah.
Yeah.
Okay, so we just need your signature, essentially, because they need to be school sponsored.
Exactly. So what happened was the school denied it again.
Okay.
And this time they cited 0 reasons.
They just said, no, thank you?
Yeah.
Ooh, I'm wondering what's going on with the ice hockey club, right? Like, what are they doing in this whole thing? Because it seems like they should be part of the conversation. I guess, like, the lawsuit is against the school, right? Because they're violating Title IX. But I'm wondering, like, what is going on in their heads to not approve this team? It sounds like it's pretty much done. Do they just not want to have to, like, manage another team?
Who knows?
Yeah.
But they're doubling down and saying no.
Yeah. They're being a little intractable.
I guess so. So the frustrations are pretty high at this point. They once again asked the district to allow them to create a school-sponsored team that's independent of the ice hockey club.
Right. Okay. So there it is. It sounds like it's the ice hockey club that's really
saying they're not going to do it.
Yeah, that's holding them up.
Yeah. So the district also says no to that request as well.
Okay, so it sounds like it's both of them then.
That's what it sounds like.
Yeah.
It sounds like they went to the district said no, they went to the ice hockey club. The ice hockey club said no.
No, thank you.
But it's important to note that in order to compete in this league, you have to have a district sponsor. So there's no requirement that you have to be involved with that booster club. Okay. So you can, so that's why they asked, separate of that booster club,
right?
Will you create a team?
Yeah.
And sponsor a team? And the district said no. again.
Right. Well, the district also probably doesn't want to ruffle feathers with the booster club either, right? Like,
yeah,
it would kind of be seen as like almost creating a rival entity.
A rival club. Yeah.
Yeah, right.
Yeah. So the parents go all the way to the superintendent of the district, and they start expressing concerns that the district is unfairly discriminating against these female students. One of the interesting things here is that the superintendent essentially says that his hands are tied and that the decision is completely in the hands of the ice hockey club and not the district, which is kind of counter to what the district has said.
Yeah, right. And this is kind of that, you mentioned finger pointing earlier, right? Like, it seems like this might be a little bit of finger pointing where it's like, look, that's not our call. That's their call.
Right. Yes. So then the girls decided that they were going to file a Title IX grievance with the district's Title IX coordinator, alleging sex discrimination, because that's, we've talked about it before on this show. That's what Title IX is about. So, one of the things that really gets me in this case is that while the Title IX complaint is being investigated, the ice hockey club and the district announced that they are adding a high school junior varsity ice hockey team to accommodate the boys who did not make the high school varsity team.
Get out of here.
Oh, yeah. This is because up until this point, one of the things that I was thinking was, okay, listen, what if there were 15 other kids who didn't make that team because of skill set or whatever? Is it a bad look that all of the girls who tried out also did not make that team? Yeah, that's a bad look. But,
for sure.
There's a skill set sort of consideration.
It could also be resources, right? Like,
we don't have enough for a second team, all these things. But the fact that we have this history of multiple teams to accommodate interest, and now the fact that we have the high school making multiple teams to accommodate interest.
Yeah, it's a lot harder to say. It kind of throws
that argument.
Exactly.
Yeah.
Right.
Yeah.
Yeah. It's very hard to say, oh, no, we can't make a second team for reasons, and then turn around and make a second team.
Yeah.
Right?
Exactly. But Chris, wait, there's more.
Always.
So the district completes their Title IX investigation.
Okay.
And you want to know what their findings were, Chris?
I bet I can guess.
Can you?
Yeah. No violation.
Yeah, because that's why we have a court case here. Yeah, they came back and they said, you know what? The district is in compliance with Title IX because the district was fully and effectively accommodating the athletic interest of the girls enrolled in the school, I guess, by just having them able to try out for the team. That, in the district Title IX investigators' minds, that's enough to satisfy Title IX. It's just allowing kids to try out,
right?
Which was a real interesting thing for me to read, because that doesn't sit right with me. And it didn't sit right with the parents either.
No, it didn't. Because, unsurprisingly, if we're talking about it,
everybody went home happy.
Exactly. Right. Yeah. They were all done. And they're like, oh, I guess we'll go find another ice hockey team. No, of course not. They filed a lawsuit.
Yay.
Yeah, I don't know.
Yay for us. Not yay for them.
Well, yeah, yay for us.
Yay,
right?
Yay for Chalk and Gavel.
Yay that we have stuff to talk about. So they sued the district and the ice hockey club in the U.S. District Court for the Middle District of Pennsylvania. So they're arguing federal Title IX claims and 14th Amendment equal protection claims, basically arguing that the school violated those legal protections because they failed to accommodate these female athletes. So they filed their lawsuit in August of 2022, and then 4 days after they filed their lawsuit, they file a motion for a preliminary injunction.
That's basically saying, we want the school to stop doing what it's doing.
Exactly. Yeah. A preliminary injunction is essentially asking someone to stop doing something that you think is unlawful and that is causing you irreparable harm. So it's the plaintiff's way of saying, I think I'm going to win this thing, but if we let this thing go through the whole process, then I will continue to be harmed, and I'll be harmed in a way that the court won't be able to fix later.
Right. So you need to stop this thing while we continue this court case, because if you don't stop it, that could be really bad.
Exactly.
The two questions that the court has to answer at that point is, does the case have merit, right? And would there be harm if we didn't do this injunction, right?
Right. Yeah. So that's kind of wrapped up in the 4 factors that courts look at when they're evaluating whether or not to issue a preliminary injunction. So the 4 factors are whether the person asking for the injunction has shown a reasonable probability of success on the merits. So Jamie, to your point, that's that probability of success.
Okay.
2, you have to show whether or not you would suffer an irreparable harm if you didn't get this injunction. 3, you have to show that granting the injunction, you basically have to balance the potential harms here between the person asking for the injunction and the person who is being enjoined. So it's kind of the balancing of the harms thing. You want to make sure that
you want to make sure that the school is not going to be harmed.
Exactly. Or if they are going to be harmed, that the harm to the plaintiff, the students, outweighs that harm.
That, right.
Yep. And then the last thing you have to ask is whether or not granting the injunction will be in the public interest. So you weigh all of those factors together, and that tells you whether or not to grant a preliminary injunction. Typically, the first and second question, the ones that Jamie, you kind of articulated, like those tend to be the most important, right? So like, do you have a likelihood of success on the merits, and are you being harmed? And is that harm something that can't be fixed after the fact?
Okay.
So let's start with that first factor, likelihood of success on the merits.
So basically this is asking, do these girls, could they potentially succeed on their Title IX claim here? And
not could they potentially, are they reasonably likely to? So this is more than just like you might win, you might not win. This is I think you're likely to win.
Okay. So it's a little bit of a higher standard to meet.
It is a higher standard. Yeah. So this isn't like a motion to dismiss where you just have to prove plausibility, right?
Right.
No, this is and that's why these are so important. Like these typically happen really early in the process, these motions for preliminary injunctions.
Yeah, because you're basically saying you're doing something that you really shouldn't be doing. And we're going to ask you to stop doing that thing while this whole thing plays out.
Right. And if a court agrees with us, that means they agree that we're likely to win this thing.
That's interesting.
And that's huge for the plaintiffs, right? The people bringing the lawsuit.
Yeah.
So,
because it gives them potentially a lot more motivation to just, circle the wagons and, push forward.
Yeah. The writing is on the wall. If you lose a motion for preliminary injunction, there's a good chance you're going to lose the whole case, depending on how the facts develop and all that other fun stuff.
So since Title IX is essentially at the heart of this whole case, let's just quickly remind our listeners what Title IX says. And it's actually a pretty, for as much of our K-12 and higher ed system has to deal with Title IX stuff, it's really big, it's really complicated, there's a lot to it, but the actual language of Title IX is pretty short and sweet. And it just says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Okay? That's it. That's Title IX. And that's the heart of this case, right?
That's the heart of this case, yeah, because that is going to tell us whether or not these students have a likelihood of success on their claim, and they're only arguing their Title IX claim here. They're not arguing their Equal Protection Clause claim.
Okay.
So we're just going to talk about Title IX. So Jamie, what you just read, that's Title IX. That's the statute of Title IX. It's federal law. But as we've talked about before, Title IX gets interpreted, right? And that's where a lot of the complications come from in Title IX.
Right.
And so there's these regulations from the Department of Education from the 1980s, actually, or 79 or 80, where the department interprets Title IX, and those regs say that a recipient which operates or sponsors interscholastic, intercollegiate, club, or intramural athletics shall provide equal athletic opportunities for members of both sexes.
Okay, so that sounds very clear to me that just saying we've partnered with this other club, this outside organization, is not going to be enough.
Doesn't relieve you of
Title IX.
Yeah, right. Yeah, so we've got this regulation interpreting the statute, and Jamie, you said it sounds really clear, but how do you define equal athletic opportunities?
Well, the school is basically saying, by allowing you to try out, we have provided you with that equal opportunity.
Right. That's the school's position, or that's one of the school's arguments, for sure.
Yeah.
But this is where another guidance document comes in. So we've got our statute, we've got our regulations, and now we've got a guidance document from the Department of Education that seeks to define equal athletic opportunities.
Okay.
So this is where that 3-prong test for determining equal athletic opportunities under Title IX comes in.
A 3-prong test? A hat trick?
Yep, we've got a hat trick. We actually have a hat trick of tests too. So like
3-prong tests?
Well, we've got 3 tests, 2 of which have 3 prongs. So yeah, 2 of them are hat tricks, but we've got a hat trick
of tests.
Not a hat trick of hat tricks, unfortunately.
Right, okay. That would have been fun.
That would have been better. But for some reason, the PI test has 4 factors. I don't know.
You know what?
They weren't they weren't thinking about us when they wrote that.
Yeah, we'll write a letter.
So this 3-factor test is really prevalent. This is how most schools and universities determine whether or not they meet Title IX's requirement that they provide equal athletic opportunities for men and women.
Okay.
So schools only have to meet one of these 3 prongs.
Okay.
If you meet any one of them, you are good to go. So the 3 options are whether or not you've got substantially proportionate numbers of male and female athletes, and that's proportionate to their enrollment. So like if you've got 50% men and women, 50% of your athletes are men and women.
Yeah. Okay, got it.
Another one of the prongs that you can meet is whether or not the institution has a history and continuing practice of expanding participation opportunities that are responsive to developing interests and abilities. So,
so basically, like if the school district has this history of saying, hey, whenever there's been interest, we've worked to accommodate that interest.
Yeah, and we're continuing to work towards meeting those interests.
Okay, all right.
Yeah.
That's the second one.
And then the last one that you can meet is that the institution is fully and effectively accommodating the interests and abilities of the underrepresented sex.
Okay.
So you can either say like, hey, we're moving towards it, or you can say, no, look, we actually meet it. We meet student interest.
Okay.
And that last prong is essentially trying to figure out whether or not the difference in participation is based on differing interest levels rather than like sex discrimination. Right? Because like, hey, we're not proportionate to our student enrollment, but that's because
those people aren't interested.
Exactly. Yeah. They just aren't as interested in sports as others.
Yeah. So it just sounds to me, these 3 prongs, these 3 questions, based on what we know here, it doesn't seem like it's looking very good for the school.
Right. Yeah. Yeah. And the school is like their own Title IX report. So they did that investigation, right? Their own report found that the school was not in compliance with the first 2 prongs. Their own report said, look, we don't have proportionate student athletes.
But did they say that the 3rd prong was satisfied? Because they only have to satisfy 1.
They only have to satisfy 1, and the school basically gave up on the first 2 because they said
that makes sense. I'm surprised though that they looked at the 3rd one.
Yeah, and so their argument with the 3rd one is, well, 1, it's a co-ed team. They had the opportunity to try out. That's all that the school says Title IX requires. Their follow-up argument is that, they're meeting interests at the aggregate level. So they've got 15 teams at the middle school across 8 different sports. 5 of those teams are all boys. 8 of those teams are all girls. So girls actually have more teams that they can be on.
Mm-hmm.
And 2 teams are co-ed. So like there's 10 total teams that girls can participate on. And the school is basically saying that this is more than enough to meet the athletic interests of the girls in the school because they've got these teams across, I think it was 7 different sports. So the school is basically saying like, we're meeting need.
We're meeting needs. And I guess they're also saying, listen, you don't have, even though you're interested in hockey, we're not going to do anything for you hockey wise, but we've got all these other teams you could go try out for.
Right. And there's no right to play hockey. Right. There's an equal opportunity to play hockey. Right. And so the students, on the other hand, they don't like that argument, obviously. So they're arguing that their interests are obviously not being met because they want to play ice hockey.
Right.
They don't want to play those 7 other sports.
Correct.
So, and they're also saying that like, just because you let us try out, like that isn't a real option given all the things that go into those tryouts. So like that is really just an illusionary option. You need to give us more opportunities.
Okay.
And so we promised you a hat trick of tests because in order to determine if a school meets that 3rd prong about meeting interests, we look at whether or not 3 elements exist.
Okay. A subset of 3 questions to answer that 3rd question. Okay.
Right. Yeah. So just to zoom out, we've got a 3-element test for effective accommodation inside a 3-prong test for equal athletic opportunities inside a 4-factor preliminary injunction test.
All right. We'll diagram this out for you.
Right. It's testception, right? They're just tests inside of tests all the way down. But so basically what this all boils down to is these last 3 elements to prove that a school hasn't met the interests of female students.
Got it.
So you have to show 1, that there's unmet interest in a particular sport.
Okay.
2, that there are sufficient ability to sustain a team in that sport. So basically, could you create a team and maintain it?
Yeah.
And then lastly, you have to show that there's a reasonable expectation of competition for that team.
Okay. So can we take those really quickly one at a time?
Of course.
So number one is there unmet interest in a particular sport? Well, that one seems pretty easy, right?
Right.
Like
ice hockey.
Yes, there's unmet interest. Like there's interest and the school is not accommodating it, right?
Right. Yeah, but the school is arguing that by allowing them to audition, that's not the right word, allowing them to try out.
You're such
An
arts kid.
Tipping my hand. Yeah, right. By allowing them to try out, they met that need.
Okay.
Jamie, I think you kind of alluded like this is actually pretty easy. The court rejects that argument.
Okay, good.
They say that the opportunity has to be real. It can't be illusory. You had 39 people try out. Only 19 people made it. And then even beyond that, other than letting them on their team, there's so many other things you could have done to meet students' interests in ice hockey and you didn't do it.
Right.
So the interest is obviously still there and it's unfilled.
Yes. And that leads nicely into the second thing about the school's ability to sustain the team in the sport. And they've pretty much come right out and said, we could, right? Because it's not a question of financial stuff. The players turned around and they said, we could get rink time. We've got a coach. We've got everything that we need. All we need is your signature.
Yeah.
Right?
Yeah. And the school kind of tries to argue that the students' version isn't feasible, right? So they're like, oh, it's going to be so much more logistically complex than that.
But they've done it in the past. They'd had 2 teams in the past.
Right.
Right?
Yeah. And again, the court doesn't buy the school's argument. The court completely sees that hey, they kind of gave you the entire team. They just need your signature. Exactly what you said, Jamie.
Yeah.
Yeah.
Yeah. Okay.
So then for the last question, whether or not there's reasonable expectations of competition for the team, that one is I think a slam dunk because
totally. That's the wrong sport though. That was the wrong sport.
I'm going to knock this one out of the park this time.
Oh, that's worse.
All right. Well, I'll knock this one through the uprights. All right. So
how about it's right through the 5-hole?
Is that a real thing?
Yeah. The 5-hole. It's right between the legs.
But why is it the 5-hole?
Okay. Because let's count it. I think it's 1, 2, 3, 4, and then in between the legs is 5.
Okay. So for people who can't see Jamie right now, he just pointed over his left shoulder, his right shoulder. He's doing the Macarena, essentially. All right. I mean, I know, like I said, I know nothing about hockey. So I will, okay, I'm going to put this one right through the 5-hole. That can't actually be a thing.
It's a thing, man. It's a thing.
All right. So anyway, this one goes right through the 5-hole. There's nothing to suggest that you need anything other than a school sponsorship to compete in this league. We know this league exists. So therefore, this last element is totally met. So that's 3 yeses.
Okay.
So because the students have demonstrated that there is an unmet interest in playing ice hockey and that it's feasible to allow them to create a team and to compete, they prove that the school has not met its obligation under Title IX because there is unmet interest. So they're denying them equal athletic opportunity. And the court says that you've met all this stuff, so therefore you are likely to succeed on your Title IX claim.
And then they grant the preliminary injunction?
So the court looks at the other 3 factors and they grant the preliminary injunction. They look at the irreparable harm. They say lost athletic opportunity, especially for young developing athletes. That's absolutely irreparable. There's no way to get those opportunities back.
Yep.
Right? So check box there. They look at the balance of the interest and they kind of say, look, school, you didn't tell us that you would be harmed by this. There's nothing here that seems to suggest the school will be negatively impacted by this. And we know that the students are going to be negatively impacted by this. So therefore, school, I'm sorry.
There was that last one that you mentioned a while ago about the public interest piece.
Right.
So did the court say anything about that?
Yeah, the court basically just said, and that's kind of not the easiest one, but for civil rights stuff, that tends to be a given because there's a strong public interest in preventing and addressing sex discrimination.
Yeah.
And there's a strong public interest in protecting civil rights. So that one is a slam dunk. No, I know that opened up.
Right through the 5-hole.
That one goes right through the 5-hole, right? That one, we know that's going to be in favor of the students.
Yeah. Okay.
So all of that goes for the students and they get their injunction. And the last thing the court says, and I just love this, the court concludes, the great ice hockey player Wayne Gretzky famously said, you miss 100% of the shots you don't take. His quote assumes that everyone has the opportunity to play, though. And in this case, the plaintiffs have not been given the opportunity to which they are afforded under Title IX. For the reasons stated above, plaintiffs' motion for a preliminary injunction is granted.
I love the fact that they pulled in a quote from the great one there.
Yeah, right? Like, it's such a good, and I actually think this opinion is really well written and well reasoned. It's always good to find good legal writing. But yeah, anytime you can pull in a quote from Gretzky, you got to do it.
Yeah.
Especially in a hockey case.
Totally. All right. So the big takeaways here, like Title IX athletics, the big takeaways here are if you've got interest in a sport, you've got to be very careful about denying those interested parties the opportunity to participate. You've got to have some very compelling reasons for doing so.
Right. If it's based on
based on sex. Right? Yeah, for Title IX purposes, yes.
Right, yeah, because just saying it's not, and the school never really gave good reasons, it feels like. Like, I think a part of it was that they kind of were deferring to the ice hockey club. Right. And we don't know why the ice hockey club wasn't into it. Obviously they could because they did create a second team. But yeah, like that requirement of equal athletic opportunities is something that schools have to take really seriously.
Exactly. And the other thing, I think that stood out to me here is this sort of what seemed to be like finger pointing.
Right. Between the dynamic between the school, the parents group, and these other parents.
Yeah. It just seemed like there were probably some very easy solutions here that could have made everybody happy and not caused a significant burden to the district or the league or anything like that. Like, there's no indication in this case that had they signed off on this team that these parents essentially not created, but all the hard work was done for them.
And they were going to continue to do the hard work, right?
Exactly. And all that they needed to do was get a signature. And there is no evidence anywhere in this case, at least, that providing that signature would have produced any sort of undue hardship on the school or anything like that.
Right.
It's just interesting to see how they kind of continually doubled down on this, especially when they realized what going through the Title IX investigation, like, we're really not satisfying a couple prongs of this test, and we're really not satisfying them.
Right. And like our best argument isn't a great argument.
Right.
Yeah.
Right.
There's so many opportunities for compromise in this case.
Totally.
And I think that's kind of one of the things, like taking ego out of it, right? Like, you and I from the outside can look at this, but we obviously don't know kind of the interpersonal dynamics here. We don't know kind of like how everyone was experiencing this. Cause there's a version of this story where the ice hockey club is kind of seeing this as someone kind of like trying to step on their turf, maybe, right? Like basically like to infringe on what they've got going on. It sounds like they've got a good thing going on. Mm-hmm. But, the counterbalance of that is that the school is under an obligation to provide equal athletic opportunities for boys and girls. And so we got to take ego out of it. And someone at some point should have kind of put their foot down and said, like, look, we need to do this. Right. And we need to do this because it's the right thing to do. And we need to do this because the law requires us to.
Yes. Let them play, man. Let them play.
Let them play.
Let them have a good time.
Yeah.
All right. Sweet. Do you have anything funny for the homework?
Your homework is to face off with chalk and gavel.
Well, that sounds very adversarial.
Well, no, we're gonna work together. I know.
I don't.
That's not face off with people.
What a face off is.
No, it's not. Well, face off implies like you're engaging with each other, right? Like we want them to engage with us.
Okay. Well, I'll give you that.
Yeah. So there.
Okay.
Your homework is to face off with Chalk and Gavel, and find us on social media at Chalk and Gavel. Also find our website chalkandgavel.com. We've got a feedback form up there. We'd love to hear from you. You can also find our teaching guide up there if you are thinking about assigning Chalk and Gavel to your students or staff. We also have our Patreon. You can find that at patreon.com/chalkandgavel or linked on our website. Your support means the absolute world to us, and for $2 a month, you can help us sustain the show.
All right, that sounds good. I'm going to go check my email to see if the Canadian government has revoked my citizenship for my
I'm going to go brush up on my hockey lingo.
My vast hockey knowledge. All right, friends, we'll see you back here in 2 weeks with another episode of Chalk and Gavel.